We know now that past consideration can never be good consideration. And even the exceptional cases, such as Pao On and Yao Yulong, this was the case that spelled out the three-part test, even those cases prove that past consideration cannot be good consideration, because the second part of the test tests whether at the time of formation of the contract the parties had an understanding that the goods, services, whatever the contract was for, were going to be paid for at the end. So given that there was an understanding that payment would be forthcoming, of course it's not really past consideration even in those circumstances. So past consideration can never be good consideration. Now, what about our next rule? Must move from promisee. So what does that mean? Well, in a nutshell, what it means is that consideration must always move from the promisee. If you want to rely on a contract, if you want to sue upon a contract, you must have been the person who provided the consideration. Otherwise, you can't sue. So third parties cannot provide the consideration for a contract which involves two other parties. And we have a case for this too. Cools and Baggett's executor and trustee. Now, this case tells us basically two things. Mr. Cools got into a contract with a mining company and he allowed them to mine his property, and in return they would pay royalties to him and to his wife. Now, unfortunately, Mr. Cools passed away. Now, the question then arose whether the wife was a part of that contract. And the court, this is an Australian decision, the court was split on this. In the end, the majority found that there was no contract, for the simple reason that Mrs. Cools' name did not appear at the top of the contract. It only said that it was a contract between Mr. Cools and the mining company. However, and this is important for our purposes, the court also held that the fact that Mrs. Cools did not provide consideration would not have stopped her from gaining the royalties even after her husband died. So she could have been part of that contract as long as it was a joint agreement. And in this case it wasn't, but that was basically based on the facts of the case, looking at the contract itself. So it is possible for a party to be a party of a joint agreement and to profit from the contract without having provided the consideration themselves. But again, this is fairly exceptional, and the facts in Cools set out the circumstances in which this may occur. So we now move on to the situation where someone is already obliged in some way to do something, either because there's an existing contractual obligation, or because there's an existing legal duty, or an existing public duty. So the question we ask is, if that person is already obliged to do something, can they use the performance of that something as consideration for an altogether new contract? So let's start with the existing contractual obligations. We have three cases that we're going to look at. The general rule is that when you do something under a contract that you've promised to do, you cannot use the performance of that promise as consideration for a new contract. And the case here is Stilk and Myrick. Stilk was a sailor who sailed to Russia on Myrick's ship. And when the ship got to Russia, a number of the sailors on board deserted, so they were undermanned for the return journey. Now, the ship's master promised the remaining sailors that they would get a share of the salaries which the deserted sailors would have otherwise gotten. Now, of course, you see the problem. The problem is that there's a promise for more salary, for extra money. However, in return, what the sailors are doing is what they've already promised to do anyway. So that's really the legal problem here. And unfortunately for Stilk, when they got back, Myrick said he's not going to pay because there's no contract, no consideration. And the court looked at this question, and the court agreed with Myrick, because the court said that Stilk was already under a legal obligation to do what he had to do anyway, which is to sail back on that ship. Now, regarding the fact that this was perhaps an emergency or a special circumstance, given that the other sailors had abandoned or deserted, well, the court held that given the contract itself, the one that Stilk and Myrick had signed initially, that contract made it clear that the contract extended to such extenuating emergency circumstances. So there was no argument for Stilk to make that he somehow provided something over and above what he had promised to do initially. So no consideration, no contract. However, in contrast, we can look at Hartley and Ponsonby. Very similar situation again. A sailor, Hartley, Ponsonby, ship owner, and the ship sailed, and somewhere along the way, some of the sailors deserted, and there was a promise to the remaining sailors that they would get extra payment, extra salary if they remained on board. The difference was that in Hartley and Ponsonby, there was no clause in the contract that said that the contract also extended to emergency circumstances. It basically just said it only extended to the normal duties of a sailor. So the promise to sail back in such a circumstance where a number of sailors had abandoned and had deserted was indeed something over and above that from what Hartley had promised initially to do. So initially just promised to be a sailor on a ship doing the normal things a sailor would do, and this was something over and above that. And because this was something over and above that, the court held that that was in fact consideration. So Hartley was able to claim the extra salary. Now, there's a third case which sort of muddies the picture a little bit, and this is the case of Williams and Roffey brothers. Now, in this case, it was held that the general rule that an existing contractual obligation does not constitute good consideration may not apply where there's a practical benefit to the promisor. Now, what happened in Williams and Roffey brothers was that Roffey brothers had contracted to build some houses. So that contract was with someone else altogether. Now, they also then subcontract part of that house building project to other people, and one of those people was Williams. And so Williams did his work, but then after a while he discovered that he wasn't going to finish on time, and he needed more money to finish on time. But of course, Williams had already promised in the contract between Williams and Roffey brothers that in fact he would finish on time. That was part of the contract. That was part of what he had promised in return for a certain payment of money. So what happened was that Roffey brothers promised to pay him more in return for getting the work done on time. Now, how is this different from Stilk and Myrick? Because after all, Williams has not done anything over and above what he promised to do initially. Well, the difference that the court identified was that Roffey brothers gained a practical benefit from this arrangement with Williams. And the reason why they gained this benefit was because had Williams not finished on time, then the whole project would have been delayed, and Roffey brothers would have had to have paid a fine to the main contractor, or the party who had given Roffey brothers the main contract in the first place, so the development company. So as an economic equation, all that Roffey brothers did is they looked at how much more do we have to pay Williams to get this done versus what's the penalty going to be if it's not done. What's the penalty going to be for Roffey brothers for not getting the whole project done in time? And that calculation was a very simple one. Paying Williams was a lot easier and a lot cheaper. So to Roffey brothers, this was a real practical benefit in the eyes of the court. Now, some people may not see that distinction between Williams and Stilk, and I'll leave it to you to see what you think. But anyway, what we note is that sometimes the rule on the existing contractual obligations does not apply, namely where there is a practical benefit to the promisor. Now, the final issue we're going to look at under the heading of existing contractual obligations is the question of whether existing contractual duties may be good consideration between A and B, where the duty is owed to someone else, C. Now, what does that mean? I think it makes a lot of sense to look at our case to illustrate what that means. Now, our case is called the Eurymedon, New Zealand Shipping and AM Satterthwaite. What happened in that case? Well, AM Satterthwaite was a company in England that made drills. And these drills were shipped from Liverpool to New Zealand, Wellington in New Zealand. And once they reached Wellington, the ship was unloaded by another company called New Zealand Shipping. So the first point to note really is that the contract, the main contract here, is between Satterthwaite and the carrier, and not between Satterthwaite and New Zealand Shipping. New Zealand Shipping was just an agent of the carrier, basically the company whom the carrier had hired to unload the ship. Now, that contract between Satterthwaite and the carrier contained limited liability clauses. That means there was clauses in those contracts, or in that contract, that stated if anything went wrong, if goods got damaged and so on, that the liability would be limited in certain ways. Now, these are very common clauses, and there's nothing unusual about that at all. Neither is there anything unusual about an additional clause which said that these limitation clauses would apply both to the carrier as well as to any agents of the carrier, such as, for instance, New Zealand Shipping. Now, when New Zealand Shipping got sued, and this matter went all the way to the Privy Council, the question arose as to whether there was a contract between New Zealand Shipping and AM Satterthwaite. In other words, whether New Zealand Shipping could rely on the exclusion clauses, which it could only have done if it provided consideration to Satterthwaite. But the only consideration it supplied was unloading the ship, which was a pre-existing contractual obligation which New Zealand Shipping had with the carrier. Can that then be good consideration vis-a-vis Satterthwaite? The court said, yes, it can. And here's how. First of all, the court looked for an offer. The court said the offer in this case is the fact that Satterthwaite signed the original contract, which included this clause that the limited liability would be extended to agents. So it was a unilateral offer, just as what we know from Carlyle and the Carbolic Smokeball Company. That offer was accepted the moment that New Zealand Shipping unloaded the ship. So by doing that, they basically accepted by performance. But what about the question of consideration? This was the tricky one. And the court held that this performance, this unloading the ship, was a benefit to Satterthwaite. And therefore, that was consideration for the agreement that between Satterthwaite and New Zealand Shipping, that New Zealand Shipping could rely on these limited liability clauses. So that is the Euromedon, and that is why sometimes a contractual duty and obligation that you have with someone else could be consideration for a contract with another party altogether, as we've just seen. Now, the next category of pre-existing duties is where there is an existing or pre-existing legal duty. So what happens when you already have a legal duty to do something? Can you then use the fact that you've done it or that you're doing it as consideration for a contract? And the answer is that you can, but it needs to be something a bit more than this strict legal duty. And there's only one case because the rule is fairly straightforward, and that case is Ward and Byam. Now, in Ward and Byam, there was a father and a mother who had a child, and the mother eventually moved out. The father then gave the child to a neighbor to look after and paid the neighbor an amount of money in order to do that. Now, when the mother got a job and got her own place, the father agreed that the child could move in with the mother. The father also agreed that if the child was well looked after and happy, then he would pay the mother what he had previously paid the neighbor. Then, of course, the father refused to pay, saying that there was no contract because the mother had a legal duty, a pre-existing legal duty to look after her own child, which of course is true. But the court said that since, in this case, the father and the mother had agreed that the child would be well looked after and happy, this was beyond the existing legal duty. So the fact that the father and the mother had agreed that the child would be treated in a way that it would be happy, whatever that means, meant that under their agreement, the mother promised to do more than just her legal duty alone. Now, of course, we can argue about whether a mother has the duty to make her child happy, whether that's a legal duty. But what we take away from this case is that an existing legal duty may be good consideration if we can show that what is being done is in some way over and beyond, as in this case, can be something so small as keeping a child happy. So as long as you can show that there is something like that, the existing legal duty may be good consideration. Now, the situation is somewhat similar where there is an existing public duty. The general rule is where there is a public duty, performance of that duty cannot amount to good consideration. And so we can look at a very old case, Collins and Godefroy, for guidance on this. So in Collins and Godefroy, someone was asked to appear as an expert witness at a trial. In the end, they were never called. At the same time, that same person who was asked to appear as an expert witness had also been subpoenaed on a related matter. So of course, when you're subpoenaed to appear in court, you don't get a choice. It's your public duty. You have to show up. And afterwards, when that expert witness tried to claim compensation by way of contract for having appeared in court, notwithstanding that the person never appeared, the court held that since that expert witness had to be there anyway, pursuant to the subpoena, they had not provided anything beyond what their public duty was anyway. They would have had to have been there anyway. They would have lost their time sitting around anyway. So there was no contract because there was a lack of consideration. Now, an exception applies where there is any additional work, additional service done over and above the public duty. So for this, we look at the case of Glassbrook Brothers and Glamorgan County Council. Now, in this case, the Glassbrook brothers had asked for police protection. Now, the police had evaluated the situation, and there was an industrial matter going on. And the police had determined that the amount of protection provided would be that police would be sent around on patrols, on regular patrols. But Glassbrook wanted more. They wanted extra police protection. They wanted someone there permanently. So the police provided that extra service, but later asked to be paid for it. And Glassbrook then argued, well, we shouldn't pay for it because it's the police's duty to be there anyway. The court held that the police did more than what they were under a public duty to do. So their public duty was basically determined by their assessment of the situation, which was that they should only send a patrol on a regular basis. Now, anything beyond that, anything beyond what the police had determined the situation required, had to be paid for. And so in this case, Glassbrook had to pay for the extra police protection.